After 29 years maintaining legal compliance, the CEO called me a blocker and fired me. The phone call came at 7:23 a.m. on a Tuesday. I was reading the morning news with my coffee when I saw it. The headline that made me choke on my first sip: Remnext Technologies accounts frozen, federal investigation underway. Below it a smaller subheading: CEO Nathan Cross unavailable for comment. I set down my mug and smiled for the first time in months. Sometimes justice has perfect timing. My name is Adrian Doolittle, and for 29 years, I was the guardian angel Remnext Technologies never appreciated. I started there in 1995, fresh out of law school with a specialty in corporate compliance, when the company was just 15 employees working out of a converted warehouse in Newark. Back then, Remnext was a scrappy little software company trying to make sense of the emerging internet economy. I watched that company grow from startup to Fortune 500, from 15 employees to 15,000, from one product to a global technology ecosystem. Through every expansion, every acquisition, every pivot and restructuring, I was there. The guy in the corner office making sure we didn't break any laws while we broke new ground. Remnext Technologies became a powerhouse in cloud infrastructure and data management solutions. We handled everything from small business accounting software to enterprise-level government contracts. By 2020, we were processing financial data for half the Fortune 1000 and managing sensitive information for 3 federal agencies. That kind of growth doesn't happen without someone paying very close attention to regulatory compliance. I wasn't just a lawyer shuffling papers. I was the institutional memory of every regulation we'd ever navigated, every audit we'd survived, every close call we'd avoided. I knew which government contracts required specific security clearances, which international clients triggered export control requirements, and which data handling procedures kept us out of federal court. My team of 12 compliance specialists was lean but effective. We prevented problems instead of just reacting to them. Over the years, I'd built relationships with regulatory agencies, industry oversight committees, and legal departments across our sector. When new regulations emerged, I was often consulted by industry groups for implementation guidance. When government investigators had questions about standard practices, my opinion carried weight. I'd testified before congressional subcommittees twice and had co-authored 3 white papers on technology sector compliance. Most importantly, I'd kept Remnext clean. In 29 years, we'd never faced a major regulatory violation, never paid a significant fine, never been subject to a federal investigation. While our competitors dealt with scandals and sanctions, Remnext maintained a reputation for ethical business practices. That reputation opened doors, secured contracts, and kept our stock price stable even during industry turbulence. But somewhere along the way, compliance became seen as an obstacle rather than an asset. The new generation of executives viewed regulatory requirements as speed bumps on the road to innovation, not guardrails preventing disasters. Everything changed when Nathan Cross became CEO 18 months ago. He'd been recruited from a Silicon Valley unicorn with promises of disrupting our disruption and moving at the speed of technology. Our first executive meeting should have been a clear warning of what was coming. "Adrian, right?" he said, barely glancing up from his phone. "I've been reviewing your department's impact on development cycles. Your approval processes are adding 6 to 8 weeks to every product launch. Those processes ensure we meet regulatory requirements," I replied carefully. "Especially for government contracts and international clients. The delays prevent us from being competitive." He finally looked at me, his expression impatient. "Look, I appreciate that you've kept us out of trouble, but we're done playing defense. The market moves too fast for traditional compliance frameworks." I felt my stomach tighten. "Nathan, we handle classified data for federal agencies. We process financial information for banks. We can't just accept that bureaucracy is inevitable." He stood up, pacing behind his desk. "I want you to work with our innovation team, streamline these processes, find ways to maintain compliance without strangling development." The meeting ended with him assigning me to collaborate with his new Chief Disruption Officer, a 28-year-old MBA named Tyler, who'd never worked in a regulated industry. Over the following months, Tyler's optimization initiatives systematically dismantled safeguards I'd spent decades building. They replaced comprehensive security reviews with automated scanning tools. They eliminated mandatory waiting periods for regulatory submissions. They created fast-track approval processes that bypassed traditional oversight mechanisms. When I raised concerns about specific risks, Tyler would respond with buzzwords about agile compliance and regulatory innovation. The breaking point came during our quarterly board presentation. I'd prepared a detailed report on emerging regulatory requirements, including new federal guidelines for data handling and export controls. Nathan interrupted me 3 slides in. "Adrian, this is exactly the problem. You're focused on limitations instead of opportunities. We need to be asking how we can work within regulations, not how regulations work against us." "I am showing you how to work within regulations," I said, trying to keep my voice steady. "These requirements aren't suggestions, they're legal obligations. They're interpretations of legal obligations." He gestured dismissively. "And interpretations can evolve." That phrase haunted me for weeks. Interpretations can evolve. It wasn't just wrong, it was dangerous. Federal regulations aren't subject to creative interpretation, especially when they involve national security and financial privacy. 3 weeks later, Nathan called me into his office one final time. "Adrian, you've had a great run here, but it's time for new thinking. We're restructuring the compliance department, and frankly, your approach doesn't align with our vision. We're done with red tape." "Red tape?" The words came out sharper than I intended. "Nathan, that red tape has kept this company out of federal court for 3 decades. He smiled, that Silicon Valley smile. "And we appreciate that. But we're not the same company we were 3 decades ago. Tyler will be taking over compliance integration. We'll handle the transition." I left in silence, but my mind was racing. They weren't just firing me, they were dismantling the entire framework that kept Remnext legally compliant. And I knew exactly what would happen next. I should have taken my severance and moved on. At 56, I had enough saved for early retirement, and plenty of firms would have welcomed my experience. But something about Nathan's cavalier attitude toward federal regulations gnawed at me. Remnext wasn't just another tech startup. We handled classified information, processed sensitive financial data, and maintained security clearances for critical infrastructure projects. I started making discreet inquiries. First, I called Maria Gonzalez, my former counterpart at Data Secure Industries, Remnext's biggest competitor. We'd maintained a professional relationship through industry conferences and regulatory working groups. "Adrian, I heard about your departure," she said carefully. "Industry talk is that Remnext is implementing some aggressive compliance strategies." "What kind of talk?" "The kind that makes other companies nervous. Rumors about accelerated approvals, streamlined security protocols. Nothing concrete, but enough to make people wonder if Remnext is cutting corners." My next call was to James Morrison, a former colleague who'd left Remnext 2 years earlier to join a regulatory consulting firm. His assessment was blunt. "They're playing with fire, Adrian. I've heard through back channels that they're interpreting export control requirements very liberally, and there are questions about their data handling procedures for government contracts." "What kind of questions?" "The kind that federal investigators ask when they think someone might be violating the Computer Fraud and Abuse Act." That phrase sent a chill through me. The CFAA carried serious penalties: criminal charges, massive fines, loss of government contracts. If Remnext was indeed taking shortcuts with data security, they weren't just risking regulatory violations. They were risking federal prosecution. I needed more information, but I had to be careful. My severance package included a non-disclosure agreement and a non-compete clause. I couldn't actively work against Remnext, but there was nothing preventing me from staying informed about industry developments. My breakthrough came from an unexpected source. Dr. Patricia Kim, a cybersecurity researcher at Georgetown, had been tracking data breach patterns across the technology sector. We'd worked together on an industry white paper 3 years earlier. "Adrian, I'm glad you called. There's something unusual happening in your sector. We're seeing increased vulnerability testing activity targeted at companies with government contracts, not actual breaches but probing, like someone's testing defenses. Which companies? I can't share specifics, but the pattern suggests targeting of firms that have recently changed their security protocols, companies that might have created gaps during transition periods. The implication was clear. Remnext's streamlined security measures might have created vulnerabilities that hostile actors were already identifying. If foreign intelligence services were probing Remnext's systems, and if Remnext's new protocols weren't adequate to detect or prevent intrusion, the company could be facing espionage charges in addition to regulatory violations. I needed allies, but I had to choose them carefully. My first approach was to Linda Chen, the senior compliance manager who'd worked under me for 8 years. We met at a coffee shop in Morristown, far from Remnext's Princeton headquarters. "I can't be seen talking to you," she said immediately. "Tyler has made it clear that contact with former personnel is discouraged, especially from the old compliance regime. Linda, I need to understand what's happening with the federal contract protocols. Are they still following the security clearance procedures?" She stared into her coffee for a long moment. "That's complicated. Tyler implemented what he calls parallel processing. Instead of completing security reviews before beginning work, they start development while reviews are ongoing. That's not legal for classified contracts," I said quietly. "You know that. I know that. You know that. But Tyler says the contracts don't explicitly prohibit concurrent development, just unauthorized disclosure. He's interpreting the requirements creatively." "Linda, creative interpretation of security clearance requirements is how companies end up under federal investigation." She looked around nervously. "There's more. The export control documentation has been simplified. Instead of comprehensive, country-by-country analysis, they're using automated screening based on IP addresses and billing locations." This was worse than I'd feared. Export control violations weren't just regulatory infractions, they were national security issues. If Remnext was using inadequate screening procedures and sensitive technology ended up in the wrong hands, the penalties would be severe. "What do you need from me?" Linda asked finally. "Documentation, not confidential material, just policy changes and procedural updates. Things that would be in the public record if anyone knew to look for them." 2 days later, she sent me an encrypted file with Tyler's new compliance frameworks. Reading through them was like watching a slow-motion disaster. Every safeguard I'd built over 3 decades had been either eliminated or weakened. Security reviews that used to take weeks now happened in days. Export control screenings that used to require human verification now relied on automated systems. Financial data handling procedures that used to involve multiple approval layers had been streamlined to single-point authorization. I reached out to my contact at the Treasury Department's Office of Foreign Assets Control. Catherine Walsh and I had worked together on export control guidelines for the technology sector. I couldn't reveal Remnext-specific procedures, but I could ask hypothetical questions about compliance requirements. "Adrian, good to hear from you. I heard you'd retired from Remnext." "Semi-retired. I'm doing some consulting work on compliance frameworks. I have a hypothetical question about export control screening procedures." I described Tyler's automated screening system without naming Remnext specifically. Catherine's response was immediate and alarming. "That system wouldn't meet our minimum requirements. Automated screening is supplementary to human review, not a replacement for it. Any company relying solely on IP-based screening would be vulnerable to both evasion and false positives." What would happen if a company implemented such a system? Depends on the outcome. If sensitive technology ended up in prohibited countries, we'd be looking at significant penalties. Civil fines, criminal charges for executives, loss of export, privileges. The works. I made similar inquiries with contacts at other agencies. Each conversation confirmed my growing certainty that Remnext was headed for disaster. The question wasn't whether they would face investigation, but when and how severe the consequences would be. My fears materialized faster than I expected. 3 months after my termination, I received a call from Linda. She was barely holding back panic. "Adrian, something's happened. We just got notification from the Defense Contract Management Agency. They're conducting an irregular security audit of our classified projects. When? Tomorrow. No advance notice, no preparation time. They're sending a full team. Irregular audits were serious business. They only happened when agencies suspected actual violations, not routine compliance issues. Someone had flagged Remnext's procedures as potentially problematic. Linda, document everything. Every question they ask, every area they examine, every concern they raise. And whatever you do, don't let Tyler handle the interactions alone. The audit results weren't made public, but industry contacts told me the outcome. Remnext's security. Clearances for 2 major contracts were suspended, pending further review. The company's stock price dropped 12% in one day. Nathan's response was predictably tone-deaf. He held a press conference blaming bureaucratic overreach and regulatory ambiguity. He insisted that Remnext's procedures met all legal requirements and suggested that competitors were using regulatory agencies to hamper innovation. That press conference was a mistake. Federal investigators don't appreciate being called bureaucratic overreachers, especially when they're conducting legitimate security audits. Nathan's combative tone escalated the situation from routine investigation to adversarial review. 2 weeks later, I learned that the Treasury Department had opened its own inquiry into Remnext's export control procedures. A routine software update had triggered automated flags when it was downloaded from servers in restricted countries. The automated screening system Tyler had implemented hadn't caught the violation because it relied on billing addresses rather than actual user locations. Tried to reach Linda again, but she wasn't returning calls. Through industry contacts, I learned that Tyler had imposed a communication lockdown. No Remnext employee was authorized to discuss compliance matters with outside parties, including former colleagues and industry contacts. The isolation strategy backfired. Instead of containing the damage, it signaled to investigators that Remnext was uncooperative and potentially hiding additional violations. Federal agencies don't respond well to stonewalling, especially during security investigations. My final attempt to help came through an intermediary. Catherine Walsh from Treasury called me directly. Adrian, I'm calling in a personal capacity. We've been asked to provide input on Remnext's compliance history for an interagency task force. Your name came up as someone who might have institutional knowledge. What kind of task force? The kind that coordinates multiple investigations. FBI, Treasury, Defense Department. They're looking at whether Remnext's compliance failures constitute a pattern of willful violation rather than isolated incidents. This was the nightmare scenario I'd tried to prevent. A multi-agency task force meant criminal charges were under consideration. The FBI's involvement suggested potential espionage or fraud charges if Nathan and Tyler had created a pattern of willful regulatory violations. They weren't just facing corporate penalties, they were facing prison time. Catherine, I signed a non-disclosure agreement. I can't provide specific information about internal procedures. I understand, but if you were asked to testify about industry standards and best practices, hypothetically, would your non-disclosure agreement prevent that? The implication was clear. They weren't just gathering information, they were building a case, and they wanted my expertise to establish that Remnext's procedures fell far below industry standards. Hypothetically, testimony about industry standards wouldn't violate any agreements I've signed. Good to know. You might be hearing from some colleagues in the coming weeks. The turning point came from an unexpected source. My former assistant, Janet Morrison, no relation to James, had been transferred to Tyler's team after my departure. She called me on a Saturday morning, her voice shaking. Mr. Doolittle, I need to tell you something, but I'm scared. Tyler made us all sign additional NDAs, and he said anyone caught leaking information would be prosecuted. Janet, what's wrong? It's about the Meridian project. You remember the financial data integration system for the Treasury Department? I remembered it well. Meridian was a $50 million contract to develop secure data sharing protocols between Treasury and other federal agencies. It required the highest level of security clearances and involved processing some of the most sensitive financial intelligence in the government. What about it? Tyler accelerated the development timeline. Instead of waiting for full security clearance approval, he authorized the development team to begin work using simulated data that matches the structure of the real data. My blood ran cold. Janet, please tell me you're not saying what I think you're saying. The simulated data isn't simulated. It's anonymized, but it's real Treasury data. Tyler said it was more efficient than creating fake datasets, and that anonymization met the security requirements. This wasn't just a compliance violation, it was a federal crime. Using real Treasury data without proper authorization, even if anonymized, violated multiple statutes. The Computer Fraud and Abuse Act, the Privacy Act, possibly even espionage laws if the data contained classified information. Janet, you need to document this, everything. Who authorized it, when it happened, what data was used, and you need to report it immediately. To who? Tyler controls all internal reporting now, and I can't go to outside authorities. The NDA says that would be corporate espionage. That NDA is void if it's being used to cover up criminal activity. Janet, this is exactly the kind of situation whistleblower protections are designed for. I gave her the contact information for the Treasury Department's Inspector General office and walked her through the process for filing a protected disclosure. 3 days later, she called back. I filed the report. They're sending investigators this week. But Mr. Doolittle, Tyler figured out it was me. He's threatening to have me prosecuted for violating the NDA. He can't prosecute you for reporting criminal activity. But Janet, you need to be prepared for this to get ugly. Tyler's going to try to discredit you, and RemNext's legal team is going to claim you're a disgruntled employee making false accusations. I'm scared, but I couldn't live with myself if I stayed quiet. You taught us that compliance isn't just about following rules. It's about protecting people. Her courage humbled me. A 26-year-old assistant was willing to risk her career to do what was right, while I'd been sitting on the sidelines trying to protect myself. That conversation changed everything. I contacted my attorney and had him review my severance agreement. The non-disclosure clause had exceptions for legally required testimony and whistleblower protections. If federal investigators asked for my cooperation, I was legally obligated to provide it. I called Catherine Walsh back that afternoon. Catherine, if that hypothetical testimony we discussed becomes non-hypothetical, I'm prepared to cooperate. Fully. That's good to hear, Adrian, because it just became very non-hypothetical. The coordinated law enforcement action began at 6 a.m. on a Thursday. FBI agents executed search warrants at RemNext's headquarters, Tyler's home, and Nathan's residence. Treasury investigators seized financial records and computer systems. Defense Department security officers suspended all classified contracts pending investigation. I wasn't part of the operational team, but I was briefed by investigators the day before. My role was to provide expert testimony about industry standards and regulatory requirements. I would explain what proper compliance procedures looked like and how RemNext's shortcuts violated federal law. The evidence was overwhelming. Investigators found that Tyler had systematically bypassed security protocols for multiple government contracts. The Meridian project was just the most egregious example. They'd used similar efficiency measures for at least 6 other classified projects. Even worse, they discovered that RemNext's inadequate export control screening had allowed sensitive technology to be downloaded from servers in 3 countries subject to trade restrictions. What Nathan and Tyler had dismissed as bureaucratic red tape turned out to be critical national security protections. The most damaging evidence came from Tyler's own files. In his enthusiasm to document his compliance innovations, he'd kept detailed records of every shortcut, every bypassed procedure, every regulation he'd creatively reinterpreted. What he thought was proof of his efficiency became evidence of systematic regulatory violations. The criminal charges were filed 3 weeks later. Nathan faced conspiracy, fraud, and espionage charges. Tyler was charged with computer fraud, privacy violations, and obstruction of justice. RemNext Technologies faced corporate charges that could result in dissolution and the permanent loss of all government contracts. I testified before the grand jury about industry standards and best practices. My testimony was straightforward. I explained what proper compliance procedures looked like, identified specific regulatory requirements, and described how Remnext's actions violated standard industry practices. The defense attorneys tried to portray me as a disgruntled former employee seeking revenge, but the documentary evidence spoke for itself. Tyler's own files contained emails dismissing my warnings and bragging about circumventing Adrian's paranoid restrictions. Nathan's behavior during the crisis sealed his fate. Instead of cooperating with investigators, he continued his combative approach, accusing federal agencies of prosecutorial overreach and regulatory harassment. His legal team's strategy seemed to be based on the assumption that they could intimidate investigators into backing down. That strategy catastrophically backfired. Federal prosecutors don't respond well to intimidation tactics, especially in national security cases. Nathan's combative stance convinced them that Remnext's violations were willful and systematic, rather than negligent or accidental. The moment that defined the entire case came during Nathan's deposition. When asked about his decision to eliminate security waiting periods for classified contracts, he responded, "We needed to move at the speed of innovation, not the speed of bureaucracy." That single quote appeared in every news story about the case. It perfectly encapsulated the arrogance and recklessness that had led to Remnext's downfall. The Remnext Technologies scandal dominated industry headlines for months. Nathan was convicted on 12 federal charges and sentenced to 8 years in prison. Tyler received 5 years for his role in implementing the illegal procedures. Remnext Technologies paid $340 million in fines and restitution, and its government contracts were permanently revoked. The company survived, but barely. Stock prices collapsed, major clients cancelled contracts, and skilled employees fled to competitors. The Remnext that had once been a Fortune 500 powerhouse became a cautionary tale about the consequences of ignoring regulatory compliance. I was offered multiple job opportunities during the trial proceedings. 3 competing firms wanted to hire me as Chief Compliance Officer, and 2 government agencies offered consulting positions. But I chose a different path. I established the Doolittle Institute for Corporate Compliance, a non-profit organization that provides compliance training and consulting for technology companies. My first major client was the Treasury Department, which asked me to help develop new guidelines for government contractor oversight. Janet Morrison joined my institute. As Associate Director, her courage in reporting the Meridian project violations had made her unemployable at traditional firms. Other companies were afraid to hire someone who'd blown the whistle on regulatory violations, but her integrity and expertise made her invaluable to our mission of promoting ethical business practices. Linda Chen also joined us after Remnext's bankruptcy. She heads our consulting division, helping companies implement proper compliance frameworks without sacrificing innovation or efficiency. The Institute has grown to 23 employees and serves clients across the technology sector. We've helped 12 companies avoid regulatory violations and consulted on compliance frameworks for 2 federal agencies. Our work isn't glamorous, but it's essential. I still follow news about Nathan and Tyler. Nathan is serving his sentence at a minimum security federal prison, reportedly working in the library and teaching computer skills to other inmates. Tyler was released after 3 years and now works for a small accounting firm in Ohio. Neither man has spoken publicly about the Remnext scandal. The real victory wasn't their downfall. It was the systemic changes that followed. New federal regulations require independent compliance oversight for all companies holding government contracts. The Doolittle Rule, as it's informally known, mandates that compliance officers cannot be terminated without approval from independent board committees. I'm 61 now, and I've learned that sometimes being called a blocker is the highest compliment you can receive. Blocking bad decisions, blocking dangerous shortcuts, blocking regulatory violations, that's not obstruction, it's protection. The government didn't just freeze Remnext's accounts, they froze a company's future, a CEO's freedom, and the careers of everyone who thought regulations were just red tape. Sometimes the red tape is the only thing standing between success and disaster, And sometimes when that tape gets cut, justice has perfect timing.